Right, I got the script. I took the time to write out the script for the interaction, and then also I put in the camping law that I was cited with, both into ChatGPT, and then I asked the question, what do I say to defend myself in court? And suggestion is helpful, and just want to present that here. So I'll need to prepare a solid argument addressing both the interpretation of the ordinance and my interaction with the officer, and then there's some steps I can take. The ordinance defines camping as activities that would cause a reasonable person to believe that I'm establishing temporary quarters or lodging. I want to highlight any inconsistencies or vagueness in this definition. There's no specific area. If the ordinance only allows camping in specified areas, and I was not in one of those areas, I need to argue that my actions did not constitute camping as defined. With the reasonableness standard, I want to argue that the presence of covered windows and shoes outside the car does not definitively indicate camping. I want to bring evidence that these conditions can occur for reasons other than lodging, like for sun protection. And I have Fourth Amendment rights against unreasonable searches and seizures. I want to emphasize that the officer's demand for ID without clear evidence of a violation could be seen as unreasonable under the Fourth Amendment. The lawful detention, I argue that the detention was not lawful if the basis for suspicion, camping, was unreasonable or improperly interpreted. The interaction with law enforcement. Compliance with ID request. I want to point out that I was willing to identify myself verbally and was not explicitly refusing to comply, rather questioning the officer's authority and understanding of the law. The officer's conduct, I want to highlight any instances where the officer's conduct may have been coercive or exceeded the reasonable bounds of the situation. So I want to collect any evidence that supports my accounts of the events, such as photographs of the vehicle, of my car's condition at the time, witness statements or recordings of the interaction if available. Written accounts. Prepare a detailed written account of the interaction focusing on your compliance and the officer's behavior. See, now that's testimony, and I'm not testifying, so I don't know about a written account. I would have to turn that into more questions for Officer Oligny instead. Look at legal precedents, case law, research any legal precedent in Wisconsin or federal court that relate to camping ordinances, reasonable suspicion, and Fourth Amendment rights. Cite these cases in my defense to support my arguments. Let's see. I want to define camping as per the ordinance. Argue that the conditions observed by the officer do not meet the ordinance's definition of camping. And it's such a broad definition that they're subjecting every car to scrutiny for camping. It leaves a problem with selective enforcement on what cars they want to pick and choose appear to be camping cars. What if somebody was just transporting camping material in their car and happened to be parked in that parking lot? Okay, and I looked up sheriff's policy because they provide it online through the Outagami website. You got to do a little searching under the sheriff's page, but it's there. From 2021 is the most recent, and it says under policy 101.07, the employees will give in a courteous manner their name, office number, or other proper information to any person who may request such information, unless the employee is working as an undercover employee, or if the revealing of such information may endanger the officer or his family. Employees may request the party to identify themselves for office records prior to the employee giving his identity. So I was asking for the cop's first name before I was going to tell my name, because I want to do a reasonable investigation into who they are. But it says in the policy that, well, the cops may, so it's not shall. They can, if they want, they can ask for my name before they give me their name. So and it's just a name, but it says in here that it doesn't say that the cop has to only give their last name and that's it. Okay, that's not in the policy. It says their name, and what encompasses the name is the first name. It doesn't say full name, all right, but it doesn't say partial name, and it says only if they think they're going to be in danger do they withhold their name. But I mean, what is it? He only gives me his last name, so he thinks maybe, and he refuses to give me his first name, so he thinks he's in partial danger. I mean, that wasn't communicated anyway. He didn't communicate a feeling that he was in danger of giving me his first name, so I mean that wasn't communicated, so that's not relevant. And it says name, but I mean what his interpretation is a little different from the actual policy from 2021. So that's what's available online. There could be an updated policy on the courteous. And I mean, that's being courteous, giving your name in a courteous manner. So the manner in which he gives his name is supposed to be courteous. And it says employees will give. I mean, that's a little different. This is a police policy. It's what he referred to, but it doesn't say may. In fact, they do decipher between may. It says employees may request the party, they may request I identify myself, but it says employees will give in a courteous manner their name. So there's a difference. It doesn't say shall, but the will is a little stronger than may. Okay, so the withholding of the name by the officer is the way he's going about it is going a little bit against the policy. All right. So I want to summarize my key points. Request the court to dismiss the charges. And that's the thing. What I am doing right now is I'm going through a discovery phase where I'm asking for all the evidence I can get. I mean, that's just, I mean, and apparently in forfeiture court, I have to kind of fight for the evidence. I have to give reasons why I need that evidence. And I mean, I think it's kind of silly, but that's what I heard from the Milwaukee judge, who I believe is a municipal judge who's making that statement. But the municipal judges appear to be restricted more under forfeiture law in Wisconsin by some statements that specifically say municipal judges cannot dismiss cases, or they will face like a punishment of some kind. It didn't say judge. It didn't say judge, and I want to say judge executive, but that's not it. Judge commissioner. It doesn't say commissioner judges and municipal judges will face harsh punishment if they try to dismiss the case without approval from the prosecutor. So it's sounding like the municipal judge is a little bit below the district attorney, but when it comes to the judge commissioner, when it comes to the commissioner judge, there's no specific language about them not being able to drop the case without approval from the prosecutor first, and that's in the forfeiture language. So I find that interesting, and I'll be dealing with municipal judge on the 16th, and then the judge commissioner on the 17th. So they have a lot of similar responsibilities under this forfeiture law, but there's some interesting differences as well, specific, because it's a jurisdictional limitation that the municipal judges have. The municipal judges tend to be the lowest level judge on the totem pole, so they got the most restrictions, and so they're restricted more, paid less maybe, and restricted more. So it'd be interesting for me to find out if the judge commissioner is able to hold juries. The judge commissioner does a lot of similar work as the municipal judge, but they have more broad responsibilities as well. So that's interesting to learn about. Under the forfeiture law, which I've said before, the forfeiture law floats in between criminal and civil. It's a part of the civil procedure, but there's also criminal aspects, like, and you have to break it down with each motion that you make, which requests that you have. Like right now, I'm in the discovery phase, and there's similarities with the criminal code of procedure and the civil code of procedure, and for discovery, what I did, and I don't have it on this tablet, I put in all the information that I found relevant under the forfeiture law, which is in like the 700 series in the Wisconsin statutes. And I said, make me a discovery request under the forfeiture laws. And ChatGPT gave me some great stuff that I didn't have in my original discovery request. So I'm submitting a second discovery request, such as information having to do with how the charge, how the fine information is presented. Okay, since this is a forfeiture case, they take a different approach, and there's like, I don't know, some kind of they submit a request for this money in some way, and I have to prove why I don't owe it. So there's paperwork involved with that, how they arrange things, and I'm asking to see that paperwork, because the judge can determine how much the fine is, and that's the thing. Municipal judges are said they can't even, like, it sounds like the municipal judge can't even adjust the fine amount. So they can't drop the case, they can't adjust the fine amount, they can't extend the length of time I have to pay if they find me guilty. But the judge commissioner is able to do all that. as far as I know, because there's no wording about the judge commissioner being limited in that respect. They have a little bit more broad authority over the matter. So I'm going through the process of trying to gather the information right now. Like today, I want to go to the police station and ask who the officer was who showed up on scene, because there was 5 sheriff deputies and 1 city police officer. And I gotta look. I want to type in Appleton and then see if Google shows me the broad outline of the jurisdiction of the city. Is Plaman Park within the jurisdiction of Appleton? It seems pretty far outside on the outskirts of Appleton, and I got the impression it's not within the Appleton city limits. And so it's interesting that I saw city police out there. So I have more questions as a part of my discovery process here. I can't make a definitive conclusions quite yet, because I want those videos and police statements. Even though police statements aren't evidence themselves, police statements are just a supplemental for a reference of information. Really, everything that's relevant is on video, but I just want to make sure that I got what they're going to present and not just what I have. So I'm at that point.